practice, it will usually allow for retention of funds for living expenses or daily company costs, and depending on, so for example, if they only have 100 grand in the bank account, but they actually owe 150,000, the court may still allow them to retain some money, usually for living expenses, and also to continue to run the company on a daily basis if the company is viable. Okay, so because I suppose the net effect otherwise is that the company becomes insolvent, and that's not good for the defendant either, because the defendant will never get the money that he's owed. Okay, so that's, I suppose, another idea of he who seeks equity, and it's all about what's the best or the most just result. You can just tie in there as well that the hardship to the defendant is a huge consideration, because the courts don't consider whether or not damages would be an adequate remedy. Of course, that isn't considered with the Moravian injunction, but they still consider what hardship will be caused to the defendant in the event the injunction is granted. As we said already, the plaintiff doesn't get any proprietary right, and they don't get any priority over other creditors. In third, Chandris, Master of the Rolls Denning, set down the criteria to be taken into account in determining whether a Moravian injunction should be granted. He said, 1. The plaintiff should make full and frank disclosure of all matters in his knowledge which are material for the judge to know. 2. The plaintiff should give particulars of his claim against the defendant, stating the ground of his claim, the amount thereof, and fairly stating the points made. 3. The plaintiff should give some grounds for believing that the defendant has assets. In most cases, the plaintiff will not know the extent of these assets. He will only have indications of them. The existence of a bank account in England is enough, whether it is an overdraft or not, so in this case in Ireland or not, whether it's an overdraft or not. The existence of a bank account in Ireland, whether it's an overdraft or not. The plaintiff should give some grounds for believing that there's a risk of the assets being removed before the judgment or award is satisfied. The mere fact the defendant is abroad is not in itself sufficient. And the plaintiff must, of course, give an undertaking as to damages. If he fails, again, in a suitable case, the court may enforce the undertaking as to damages. We already know, ex parte, full and frank disclosure. The court also has discretion not to set aside a Moravian injunction. So if the defendant comes in, once he's put on notice of the injunction and says, he didn't disclose all the material facts, he should have told you this, this, and this, because that would have swayed you to not make the award or to vary the award. Just because he hasn't disclosed everything, it doesn't mean the court are obliged to discharge the order. Discharge the order meaning effectively say, okay, no, we're not going to make that order anymore. That order is finished. There's no Moravian injunction. They're not obliged to do that just because you haven't told them everything. It's totally discretionary. In Bambrick, Clark stated that in exercising the discretion to decline or refuse to discharge the order, even if it is obtained on the basis of some non-disclosure, the court should have regard to all the circumstances of the case and set out a